State here.
Good morning, Your Honor. State is here.
Morning.
Your
How are
judge.
you? Have I met Mr. ASG? I'm sorry, Supervising ASG Brown?
I have not, Your Honor, but it is my pleasure to be in front of you today.
Thank you. I try to keep up a little bit and remember names, but I
Yes,
thought
ma'am.
that might be a new name for
It
me.
is.
All right, at least it's easy to pronounce. And is it Scirocco? I try not to
That's
mess it
close
up.
enough.
Say it
I
for me again.
I get Scirocco and Sirocco. I've heard it from the same family that share.
From the same family?
Yeah, yeah.
Scirocco, I got you. It's depending on whether they're from the north or the south, right?
Mm-hmm.
I got you. All right. I think I saw Miss McLeod on there earlier. And then I see PD McLean. Okay.
Yes, Your Honor, good afternoon.
Good afternoon. All right, we'll get started, ladies and gentlemen. Good afternoon. We're going to begin our Fulton County State Court Expedited Accusations calendar. And this is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's Office has already accused the cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before state court judge, so we are able to address several matters of including bond, possible plea offer, and arraignment, arraignment and a plea offer if the state has made one at this juncture. I want to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I want to also remind the defendants on this calendar that you do have certain constitutional rights. The first being that you have a right to counsel representing you at this juncture in your case. You should know who your attorneys are and hopefully have spoken to them by now. Also, you have a right to remain silent. Remember that anything that you state about the facts and circumstances and the occurrences of your case can and will be held against you. The state is here, they're listening. So again, follow the lead of your attorney and listen to them. All right, courtroom 2, who do we have first?
We can start with position 1, Judge.
Position 1, okay. All right, this is 25 CR 00306 OG, Rashunda Bracy, charged with 2 counts of battery and 1 count of criminal trespass.
It's a 10th arrest. He got an open arson out of Mississippi. On probation for battery out of state court. 2022 probation. 2018 failure to appear. 2018 terrorist threats, criminal damage to property, 2nd degree, first offender. 2012 obstruction conviction and a 2012 ag assault, dismissed.
All right, State.
Thank you, Judge. This incident took place February 28th of this year at 3341 Martin Luther King Jr. Drive, Southwest Atlanta. It's a smoke shop. Law enforcement responded to a dispute call there, and upon arrival spoke with the first victim, in this case, Miss Ariana Thurman, who explained she was assaulted by the defendant, whom she knew, along with 4 other females. The incident stemmed from an argument the previous day involving some young males. When the females entered the store, they were being loud and disorderly, prompting Miss Thurman to tell them they need to leave, at which point they became aggressive. The defendant and the other women struck and kicked Miss Thurman several times, causing a busted lip, knocking her glasses off during the altercation. Less than an hour later, the officers called back to that location where Miss Thurman explained that the defendant was actually involved in orchestrating that incident, and apparently recorded as well. After the officer left the first time, because he returned, Miss Thurman's friend, the other victim in this case, Miss Alexis Nix, that's Nix, arrived at the store, and the defendant had contacted the same group of females to return to the scene. Another argument ensued. The defendant and those same 4 females attacked both Miss Thurman and Miss Nix, striking and kicking Miss Nix several times, pulling some of her hair out during the altercation. And both victims sustained abrasions, minor cuts, scratches, and some head pain to Miss Nix as a result of the incident that she complained of. Defendant was identified via photograph, and both the victims in this case explained that they had known the defendant for roughly a year. There was, with respect to what pretrial mentioned, the felony terroristic threats and acts, criminal damage to property in the second. For that case, where she received first offender treatment, I will mention there was also an aggravated stalking charge that was not presented to the grand jury. And that there was a battery substantial physical harm. I want to specify it was a substantial physical harm conviction from this year, where she was convicted of beating another woman, an employee, at the lounge where that victim worked, striking her in the face and giving her a black eye. Not entirely dissimilar to this here. But we have spoken with the victims in this case. Miss Ariana Thurman explained that she and the defendant used to be friends, explained the incident location was where she was working, and the defendant had previously been banned from the location, told not to return, or told not to sell anything to the defendant, the victim was told. She came to the location, tried to buy some things, and in this instance, she refused to sell them to her. Defendant and the other people with her began to jump on her and attack her. And they then came back to the shop later that day and attacked again. She sustained a busted lip, confirming the events in the warrant. She also explained to us that she received a call from the defendant this past Saturday threatening her. She expressed to us that she wants no contact with the defendant whatsoever. I do not believe she is on the Zoom. We would ask the court sound for her when appropriate. But with respect to Miss Alexis Nix, she explained that she and the defendant also used to be friends and received a call from Miss Ariana letting her know the defendant and the other girls came there and jumped her, went to check on Ariana, and immediately a fight broke out where they started attacking her. She was, as she expressed to us, a few weeks pregnant during the incident, and the other girls were kicking her in the stomach. She ultimately lost that baby due to complications from the incident, is what she expressed to us. So she further explained she drove off. The defendant had another girl recently when she ran into the defendant this Saturday at the Verizon store, started to argue again. like I was saying, drove off. Defendant had another girl with her. She was outnumbered. And she expressed to us that the defendant and her other friends have been going to places that she frequents, such as the place where she gets her hair done, looking out for her, trying to find her. She's concerned for her safety and explained that the defendant will send her other friends to jump her, which is especially concerning when this victim has her daughter with her a lot of the time. She also doesn't want any contact with the defendant. Given the defendant's history here and her contact with the victims in this case, there is a substantial risk of reoffense and witness intimidation. As such, the state's recommendation is $3,500 surety for each of the batteries and a $1,000 surety for the criminal trespass. No further contact with Ariana Thurman, no further contact with Alexis Nix. Stay away from that smoke shop at 3341 Martin Luther King Jr. Drive, Southwest Atlanta. 2-day anger awareness, and no drugs, weapons, or alcohol while out on bond. And we would ask the court sound for Miss Ariana as well.
All right. Ariana Thurman on the Zoom. Ariana Thurman
Or Alexis Nix.
or Alexis Nix. All right. Go ahead, Mr. Chataya.
Thank you, Your Honor. Ms. Bracer requests the lowest possible bond from this court. She's 32 years old. She's lived in Atlanta for the past 20 years, so I would call her a local. She's a high school graduate. And in terms of her work, my understanding is she owns a business. It's a boutique shop that sells clothing and accessories, and she's been doing that since 2013. No objection to the state's request for no further contact or stay away. And she also informed me that she has a dog at home and the dog needs her care. So for those reasons, I asked the court to consider the lowest possible bond.
And I am very concerned about the allegations as well as the safety of the victims here. The allegations are quite disturbing. To just continue and continue. I hope we're at a point of this cooling down or stopping. And that was in February. We're in May, but it seems like she's still going around them as of last weekend. So I'm going to order the $7,000 surety bond, $3,500 on each of the batteries, $1,000 on the criminal trespass for a total of $7,000. No further contact with the victims, Ariana Thurman and Alexis Nix. And I mean no further contact. You shouldn't be within 100 yards of them on football field or 200 yards. No contacting them by phone, text, email, or any other means. No third party should be contacting them on your behalf because that could be considered a violation of your bond conditions. No drugs, alcohol, weapons, or guns while on bond. I would order the anger awareness courses, but I'll wait on that because I feel like you probably need them. But anyway, 7,000 surety.
What's some bond amounts again?
3,500 on each of the batteries and
That's
1,000.
7. So it's 8,000.
Oh, 8,000. I'm sorry. It is 8. Thanks for checking my math. 8,000.
I have a quick announcement. It's my understanding she paid the bonds for the 2 batteries already, and the only charge was the criminal trespass that didn't have a bond on it.
I did not have that information. State, someone check for me.
Oh, yeah, it is in here.
We added the criminal trespass charge, Judge, and if that's the case, then we are asking for $7,000 on the criminal trespass with the same conditions.
So what is the bond that she's paid on each of the batteries? 'Cause I don't have that.
If 5,000 each is 10,000.
Oh, 5 each.
Correct.
And that was a surety or a signature? I'm sorry,
Surety. She went
surety.
to a bonding company.
She went to a bonding company. Bonding
Yes,
company. All right. On the criminal trespass, and state has added that And the state is requesting a 7,000 on the criminal trespass.
Okay, you said it was 5,000 on each?
That's what it shows in Odyssey.
All right, we would be requesting a 3,000 on the criminal trespass then, with the same conditions as aforementioned.
Okay.
Surety.
Yeah, I will order the 3,000 surety on the criminal trespass. Since we don't have to address the two batteries. So $3,000 surety on the criminal trespass. And that's it for the court.
So since she paid the bond on the other one, she still has no further contact and everything else, correct?
All the other conditions remain. No further contact, right? And I'm sorry, and to stay away from the smoke shop.
I got it.
Okay.
Next is position 3, Ms. Childs.
25 CR 003069F, Jetta Childs, charged with 1 count of battery family violence.
Third arrest, 2022 shoplifting dismissed, 2017 shoplifting dead docket.
Okay.
Thank you, Judge. This incident took place, it was yesterday, at 315 Rosemont Court in Roswell. Law enforcement responded to a call, and upon arrival, made contact with the victim in this case, Miss Daphne Jean, who explained that the defendant, her roommate, had gotten upset with her and had thrown bleach on her face. The victim explained she left the apartment early that morning, and was having sexual relations with another individual by the name of Shez, S-H-E-Z, in a vehicle. The defendant approached the vehicle, saw what was going on, and then went back, returned with a bottle of bleach, and then threw bleach at them. The victim was the one who got the bleach on her. It was on her face. She had a strong odor of bleach coming from her person, had red, watery eyes, as the officer observed. And she had a previous relationship, the defendant, with the individual by the name of Shez a long time ago, apparently. But the defendant admitted that when she was asked about the bleach, she said she was using it on her clothes, but shortly after attempted to throw the bleach at Shez, but the victim got in the way, was what she said. Inside the apartment, the officer did discover the empty bottle of Clorox bleach without a cap on it that was apparently used in the altercation. Victim was seen by medical personnel, and the defendant was placed under arrest. We have requested that this be upgraded to a felony for aggravated assault, family violence. That is pending. Given the felonious nature of this case, the toxic substances in the bleach very well could have blinded her as well. So this may be an aggravated battery too. We don't know yet because we haven't heard from the victim. We will, of course, continue those efforts. And we ask the court sound for her when appropriate. But also, given that there's not been a sufficient cooling off period, this is a jealousy fueled incident that took place yesterday. State's recommendation here is a $3,000 surety. No further contact with Daphne Jean. Anger awareness. Stay away from 315 Rosemont Court in Roswell. And no drugs, weapons, or alcohol while out on bond.
All right. And is this your case, PD Tucker?
Yes, Your Honor.
Okay.
Ms. Childs is 25 years of age. She is an Atlanta native. She currently resides at 315 Rosemont in Roswell, Georgia. The incident location, she is on the lease. However, prior to the incident, she was packing to leave the residence, and she is prepared to move. So she does not have an issue with leaving and not residing at the incident location if she's able to get a police escort to remove her items from the property. So we are requesting and she has a very limited criminal history and no prior failure to appears. So requesting a signature bond on her behalf. And we have no objection to the rest of the state's recommendations.
All right.
Did we sound for the victim, Judge?
And I'm sorry, yes, Daphne Jean. Forgot to do that. It's
Thank you,
Daphne
Judge.
Jean. Okay. All right, I will order the $3,000 surety bond to stay away from 315 Rosemont Court. Needs to find somewhere else to live. I will order a one-time law enforcement escort to go back to get her belongings once she schedules that with law enforcement. No further contact with Daphne Jean. And no drugs, alcohol, weapons, or guns while on bond. And that's it.
Judge, the reset date for SAP is June the 12th for those that are making a good.
I know, we forgot about that. June 12th. Thank you.
Next is position 2, Mr. Brunson.
Which is 25 CR 003061E. Cameron Brunson. Charged with 1 count of criminal trespass and the 2nd count of willful obstruction. Pretrial.
This is third arrest. He was here the other day for loitering and prowling. He received a pretrial signature bond per judge. Case number 25 CR 003024E is the case number. He's on probation out of Richmond County for burglary in the 2nd. Oh yeah, I'm about to revoke that signature bond too.
Okay.
Thank you. This will be my case, Judge. This incident took place May 29th, 2025 at 505 10th Street, Northwest Atlanta, the Georgia Institute of Technology Research Admin Building. Law enforcement responded to a person trespassing call. It was like 3:40 in the morning. And on arrival, found the defendant seated at a table within the boundaries of the property. He had been issued that a criminal trespass warning on May 26, 2025, which barred him from entering the property owned and or leased by Georgia Tech until mid-2027. The officer placed the defendant under arrest. While taking him into custody, he tensed up his arms, attempted to keep them at his sides, refusing to comply with the officer's orders. And the officer had to force his hands behind his back to place him into custody. He also refused to spread his legs for the search incident to arrest. Officer had to do all this manually. He did not, excuse me. Oh, that's it for the facts. But that open case, the 25 CR 003024E, loiter prowl, that incident date was, I believe, related to this. But the Monday, the 26th, also took place on Georgia Tech property. He was given a $1,500 signature bond by Judge Law on Wednesday. And one of the conditions for that was to stay away from all Georgia Tech premises and property. So just 2 days after being given a bond order, he is in violation of that same bond order with this case. Given that, the state's recommendation is a $500 surety bond for each count. Stay away from all Georgia Tech premises and property. This is consistent with the last order, but we're asking for a social worker visit for BHET. And no drugs, weapons, or alcohol while on bond.
All right. This case is this Mr. McLean?
It's my case, Your Honor.
PD McLean. Oh, okay. PD Chataya.
Yes, Your Honor. Mr. Brunson is 24 years old. He's lived in Atlanta for the past 2 months, but prior to that, he lived in Augusta, Georgia. He lived there for his entire life until 2 months ago. He's a high school graduate, and for the past 3 years, he's been working at a McDonald's. And he also tells me that he has a 4-year-old daughter at home that he supports. He would like to request a signature bond in this case, Your Honor. And given that it's his third arrest and that it's likely that he's going to get his bond revoked in the other cases, I think a signature bond would be reasonable here.
No, I think a signature bond would be reasonable. He doesn't get it, so I'm gonna order a surety bond. I'm going to order 1,000 on the criminal trespass and 500 on the willful obstruction for a total of 1,500 surety. And once again, I'm going to order him to stay away from Georgia Tech. Don't go anywhere around Georgia Tech. It's a vast amount area downtown. No further. Well, I guess we don't have as far as a contact person. But just stay away from the campus. No drugs, alcohol, weapons, or guns while on bond. And I guess that's it. Anything else, counsel?
Nothing, Judge, aside from, I'm not sure if you wanted to also order the social worker visit for BHET, but it's,
Yes, I'll go ahead and order that.
all right.
Social worker visit for BHET. And that should be it.
Next is position 5, Mr. Hightower.
This is 25 CR 003063A, Brandon Hightower, charged with 2 counts of simple battery family violence.
23. You got to open possession of a firearm by convicted felon or felony first offender. Wanted out of Gwinnett on a neglect child case. 2023 probation, 2019 possession of a firearm by convicted felon, possession of cocaine with intent, sale of marijuana, possession of a knife or a firearm during the commission. Those were convictions. The violence I saw were dismissed, if I'm not mistaken. That's it.
So, Judge, yeah, this will be my case as well. This incident took place May 27th, 2024 at 1999 Bent Creek Way, Southwest in Atlanta. Law enforcement responded to a person down from a dispute call early that morning. And upon arrival, met with the victim in this case, Miss Kenya Reed, who explained that the defendant, who was her boyfriend of 6 years at the time, had chased her out of the residence and she had feared he was still following her. Another officer heard a man speaking to Miss Reed. I believe this was on the phone, stating, "You called the police." Officers attempt to make contact with the defendant. He wasn't on scene and couldn't be located. After canvassing the complex, she explained that this incident started out because she had told the defendant about a relationship she had had with someone else. Defendant became upset, and while Miss Reed was in the shower, the defendant came in and punched her with a closed fist. She explained that she fought back, tried to fight back. The defendant choked her while hitting her in the head repeatedly, stating that he would kill her. She stated she pleaded with the defendant to get off her before she fled the residence and called police. She explained that the defendant is a member or is involved in gang activity. And she has a restraining order on him dating back to last year, but stated she still lets him around. She expressed that she had neck pain, but would take herself to the hospital to get checked out. She positively identified him from his Georgia ID photo. And from the report here expressed that he was a wanted suspect that they discovered out of APD for intimidation, terroristic threats, that one I could speak to, and stalking. Warrant was issued for his arrest. With respect to some of the cases that pretrial didn't quite go into, there are several. There was a simple battery arrest from 2007. I'm not sure what happened with that, but I don't know if it was dismissed or what. But there was a 2017 battery and theft by taking, which were null pros, it looks like, due to evidentiary issues. But that case involved a different victim. But like here, it was allegedly a woman who was the defendant's girlfriend at the time. So intimate partner violence case. And then there was a battery, family violence, battery, simple battery, family violence, simple battery case from 2018 out of Clayton County that appears to have been null pros. He is currently being held on bond for 25 PI without bond, excuse me, on 25 PI 004253 for terroristic threats and acts and criminal trespass. The warrant for that incident states that the defendant jumped onto the car of the same victim, in this case, Miss Reed, that the same vehicle that she was in, and repeatedly threatened to kill her. The other victim in the driver's seat attempted to drive off, but the defendant clung to the hood of the vehicle, repeatedly punching it with his hands and cracking the glass. Apparently, he remained on that hood until they were able to drive that vehicle to the East Point police station, at which point he jumped off and fled. And reiterate as well, there is an open case for that receipt, possession, transport of a firearm, and that he's wanted out of Lawrenceville for that child neglect case. We've spoken with the victim in this case. She expressed that they are no longer in a relationship and no longer live together, sharing no children. She explained that the defendant did grab her by the neck. Fortunately, she states that she was able to breathe and did not feel like she was going to pass out. She expressed that she had anxiety from the situation and expressed that she was angry over the situation. She expressed to us that she already has a degenerative disc disease, and it sounds like that is what the incident here exacerbated that pain. She expressed that the defendant hasn't been violent with her in the past. I would consider that the 25 PI case to be a violent incident, or potentially violent incidents, the terroristic threats and acts. But she said there's no violence that's taken place since this incident. She's not in fear of him, wants to continue contact. She should be on the Zoom. We would ask the court sound for her when appropriate. But given the defendant's history of violent criminal cases, most of which appear to be DV or at least intimate partner, his open case, he presents a risk of reoffense here that we are concerned about. As such, the state's recommendation is an $8,000 total surety, $4,000 on each count here. No further contact with Kenya Reed. Stay away from 1999 Bent Creek Way, Southwest in Atlanta. Surrender any and all firearms to the sheriff's office, and no drugs, weapons, or alcohol while out on bond.
All right. PD, is it Chataya?
Yes, Your Honor.
Okay.
Mr. Hightower is 41 years old. He's a lifelong Atlanta resident. He got through school as far as the 10th grade and then went on to get his GED. And for the past 7 years, he has been working as a mover for the ALS Moving Company. I believe that's the name of the company. He asks the court to consider the lowest possible bond.
And if Miss Reed is on.
Yes, I'm sorry, keep forgetting Miss Kenya Reed. Kenya Reed. No. All right. I will go ahead and order an $8,000 surety bond, $4,000 on each of the charges. Stay away from 1999 Bent Creek Way. No further contact with the victim, Kenya Reed. No drugs, alcohol, weapons, or guns while on bond. And if he has any other firearms, to surrender them immediately to the sheriff's department or marshal's department, either one. And I think that'll be it. I leave out anything, council?
Did
Not
they
on
come
my
back
end,
to court
Judge.
on the 12th?
I'm sorry.
That they returned to court on the 12th?
Oh, yes. And to return to court, SAP calendar, which is June 12th. All right, that's it.
Next, we can go to position 6 and 7 at ACDC.
All right. This is 25 CR 003064C. Felicia Moss charged at 1 count of affray or fighting. The second case is 25 CR 003065C. She is charged with 1 count of criminal trespass.
36. 2025, shoplifting Nolo. 2024 FTA. 2021 simple assault. 2020 simple assault disorderly conduct conviction. 2019 FTA. 2018 simple battery conviction. 2016 credit card theft. And a 2016 possession of a controlled substance. I think she's homeless, according to the booking.
Okay. Stay.
Good morning, Your Honor. Again, as the court has heard, there's substantial history here. I will start with the argument. This incident arose from, speaking to position, excuse me, my screen just changed on me.
Okay.
There we go. For the charge involving the criminal trespass. On that day, this case arose on May the 29th, 2025, at the location of 1021 Fair Street, Southwest Atlanta, Georgia, here in Fulton County, which is known as the Fair Street Market. On yesterday, Ms. Moss went to that location where she was already previously trespassed off the property on July the 30th, 2024. Officers met with the owner or representative of that location, a Miss, and I'm going to mess this up, so I'm going to spell it, Miss Tiringo, Taringo, and it's spelled like this. Last name is Gilasse. I'm presuming that's Salas. And was informed by her that she was previously trespassed off that property. Once the defendant arrived in the location on this day, she engaged in a brief verbal altercation with some of the persons therein, became disorderly, started throwing things around and cursing loudly. She was asked to leave multiple times, but refused to do so. No one is aware of why she would come in there to do that. The history speaks for itself, Your Honor. You've heard that she has multiple FTAs. Multiple convictions, some of which are violent, and which pertain to some of what we see here in the factual basis. We're asking for a $2,500 good bond on the case involving the criminal trespass, asking that you order her to stay away from the Fair Street Market, no further contact with Mr. Ringo Salas, and any other such conditions that you deem necessary and proper. As to the, would you like me to go to the Affray case?
Yes, let's go to that one as well.
Sure, yes, Your Honor. The factual history of that, it goes a little further back than the case that we just spoke about. That this case had an offense date of June the 21st, 2024. Victim is Miss India Bethia. Location is the Joseph E. Lowry Boulevard area. While patrolling on that area, law enforcement encountered Miss Moss. And during a routine, normal police citizen encounter, was inquiring of her if she knew of another wanted individual. During that conversation, she did open in public on the public roadway a beer can, and during the conversation, she poured it out halfway after drinking it. And while the conversation was going, she engaged in a verbal altercation with a passerby known as India Bethia. Despite being given multiple commands to disengage and go home, she continued to become combative and then verbally combative and then became physically combative and engaged in physical violence toward the victim. All of these things taken together, Your Honor, these two cases, we are arguing that she's a danger to the community, very likely to reoffend, likely to flee the jurisdiction or not appear for court, and likely to intimidate witnesses based on her behavior that she demonstrated at the Fair Street Food Market. But as to this case, we would ask, in addition to the $2,500 good bond that was asked for in the other one, we would ask for a $3,500 good bond. No further contact with Indiana Bethia, no alcohol, no drugs without a prescription. Stay away from no further contact devices. Excuse me.
Okay. All right, Attorney McLeod.
Yes, Your Honor, my client is 46 years old. She is the mother of a 2-year-old that she has to take care of. She tells me that she has been unemployed for some significant period of time, Your Honor. So, of course, she has no money to pay for bond. So, I would definitely ask the court to take that into consideration. With respect to the alleged affray, this happened almost 2 years ago. It will be 2 years by this weekend, really. It will be June. It would have been 2 years. I believe the state said it happened in June of 2024. We are now almost in June of 2026. So I would definitely ask the signature bond on that one, Your Honor. As for the other charge, my client totally denies the allegations. She said she was just in the neighborhood to get something. You know, it's a store, and I don't see any real reason why she could not be there, but she certainly denies that she attacked anyone or threatened anyone, Your Honor. If she does not get a signature bond or at the very least a very, very low bond, she will not be able to get out of jail. And I would like the court to take into consideration that she has a 2-year-old. Nothing further, Your Honor.
All right. On position 6, which is the affray, I will order a $1,500 good bond, $1,500 good bond. I will order her to have no further contact with India Bethia, no drugs, alcohol, weapons, or guns while on bond. So with that one, the 1,500 good bond. Then on position 7, with the criminal trespass, a $2,500 good bond. And that is to stay away from 1021 Fair Street, just to stay away from that marketplace. No further contact with Miss Gonzalez or Gonzal, I'm sorry, Taringo, and no drugs, alcohol, weapons, or guns while on bond. And I don't know if she needs a social worker visit or for any assistance.
Your Honor, she's not working. She has no money. She has a young child. So I think that probably would be appropriate.
Okay. We'll order that as well. All right, that's it.
Thank you,
Judge,
Your Honor.
I'm sorry, Judge, for position number 7, you stated it was 2,500 surety bond?
For 7?
Yes, ma'am.
Yes.
Okay, thank you.
Okay. You all don't have anybody else over there?
No, that's it. And when is their next court date, Judge?
It'll be June the 12th.
Thank you.
All right, thank you.
CRDCC.
All right, have
Your
a good
Honor, that concludes my business before the court today. May I be excused?
I guess we'll let you go start your weekend.
Thank you, Your Honor.
All right, you're welcome.
Next is add-on 1, Mr. McCoy, and I do believe the only charge is the last charge that we're addressing. The other one
Okay.
yesterday.
All right. He has bonds on the others. All right. This is 25 CR 003034J. Is it DeKalin McCoy? And we have the last charge, unlawful carrying of a weapon. First offense. Retrial.
Hold on real quick. Let me look at something.
Okay.
Was I was looking for his booking number. Hold on.
It's 250-9719.
Okay. Second arrest. He had a 2020 burglary. He does have a DJJ hold now. It wasn't on here yesterday when we were in court, so it must have got added afterwards. Well, it did, but that's all.
All right.
All right, Your
And
Honor.
I see the person with their hand up. Is that she's connected with this case, or is this his mom?
Yeah, that's his
Yeah.
mother. She was on yesterday.
All right. I'll hold on, man. Let me hear the case first.
My apologies, Your Honor, for interrupting you. This case was on your calendar yesterday, and the incident occurred on May the 28th, 2025. While Martyr PD officer was on the train, he observed Mr. McCoy quickly transfer cars from one car to another upon his arrival upon the train without really any emergency or necessity. After seeing such behavior, officer made a routine citizen encounter, asked him to step off the train and give him some identification. During that contact with the defendant, he observed a bulge in his right front pocket that appeared to be a firearm. He was advised to keep his hands away from that bulge, despite being instructed multiple times to do so. He continued to reach for that area, at which point the officer was advised by the defendant that he had a gun on his person. He was instructed to put his hands behind his head until a law enforcement backup arrived. As soon as backup arrived, he then took flight. Shortly was apprehended there they're in the location where they were. It was determined that he didn't have a valid license for that firearm, and during his arrest, he refused to comply with lawful orders given to him by officers to comply. Your Honor, as you have already been told, he does have some history, some of which is concerning, very concerning more than this, but it's still nonetheless. We will be asking for this particular charge, given that it is a firearm and some of the facts alleged. We'll be asking for a $3,500 good bond. Other than what has already been provided by pretrial, I don't have any additional or subsequent history.
And PD McClain, guess I'll let you go first, then I'll see if I need to hear from his mom or not.
Thank you, Your Honor. Mom tells me that the DJJ folks have already agreed to put him on an ankle monitor on his probation matter. So this is the only thing standing in the way of him getting on that ankle monitor and submitting to their supervision. We would ask for a signature bond. We went through this case yesterday. Everything was in there. The charge of weapon without a license was not on yesterday, as far as I know. So we'd ask the court to just simply put this on the other bond, give it a signature bond. It's with a parental co-signer of Letitia McCoy or Randolph Williams, which is the young man's uncle. He's in high school. He works at McDonald's and some other places. Thank you.
And I know Judge Law heard this yesterday.
Yes.
Pretrial, do we have, or state, do we know that's correct with DJJ?
It's on the booking.
Well, as far as them wanting to put him back or put him on probation with an ankle monitor. So there is a hold or there isn't a hold?
There is a hold, Your Honor. I did notice that myself when I was in this case, but I don't know anything further about the anchor monitor piece. I am trying to do a little bit of digging here for their
Yeah, I don't know either.
Yeah, the mom has that information.
Okay, I'll let her speak and swear her in, but I am very concerned about the case and the charges and that he's 18. So Mom, you have your right hand already raised. I'm gonna swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, tell us your name.
Letitia McCoy,
Spell the first name.
Latisha.
Okay, and McCoy. All right, and you're the mother to DeKaylin McCoy?
Yes, ma'am.
Is he on track to graduate next year, or what's his position?
Yes, ma'am. He's on track. He's went to the next grade and everything. He goes to Perry. Perry.
All right, and so with DJJ, if someone contacted you, how did you find that out?
His probation officer called me this morning, and I called his probation officer because I texted him yesterday, and he told me that he's not gonna violate him. He's gonna give him a chance. He put back on the ankle monitor if I choose for that, and I told him I do. And I mean, he's a good kid. He don't really be in trouble, ma'am. I apologize for the incident that happened with him. Your Honor, I will
You
keep him out
froze
of
for a
trouble.
second. I didn't hear that.
His probation officer is going to take the hold off of him. He said once he came back, it was going to be sometime today, and long as we can take care of his charge, the one that was pending, that wasn't on there yesterday, but he is taking a hold off, and he'll be able to come home the weekend. He lives with me. He does work. He works at a deco with me. It's an eyeglass company. They just hired him. And he's really not a disrespectful kid at all.
Well, the charge is he had a gun on Marta.
He will not. We don't have no type of weapons at my house. We don't do no type of drugs, no nothing. Like I told his probation officer, I will keep him out of trouble and everything. His probation officer said that he's gonna be a little more stricter on him, I guess, coming to check on him more often. We don't stay that far from probation, a few blocks. And he won't have no type of access to no type of weapons, no drugs, no nothing.
What's he gonna do for the summer? What's he doing for the summer?
He's working with me. We work at Lazadica. Adeco is the temp agency.
Okay.
But he'll be at Lazadica, the warehouse working. It's in McDonough, Georgia.
Your Honor.
And on the weekends, he'll be moving furniture at a place with my guy friend.
Okay. Who was that?
Your Honor, that was myself. I was trying to
Shoot
provide
around.
the court with additional information. I do see that there is a letter from the Department of Juvenile Justice stating that he did have a hold. That letter was submitted on yesterday. It says that it is a hold to contact Officer Grant Jones. And I just want to advise the court that the offense for which he was on probation was aggravated battery.
Got some. Okay. Mom, I do hear you. And you can imagine I hear from parents a lot.
Yes.
The older the child, the less likely it can be sometimes to control them. And sometimes it doesn't matter the age, it depends on who he's trying to hang around with and things of that nature. So I'm going to definitely put on a curfew. Hold on a second. I'm going to definitely put him on a curfew, and he'll probably be on one anyway, but I will do it here. But I'm just not inclined at this time to give him a signature bond because I'm concerned about what I'm hearing. And, if the charge added wasn't with a weapon, I would not be as concerned.
I beg you to please give him a signature bond. I'm getting through eviction and stuff, and I give you my word, Your Honor.
Do you have other children?
I have a 21-year-old and a 16-year-old. I swear to you, Your Honor, I would do better with him if you would
Well,
please do that.
you may want
I
to do
beg.
better. You may want to do better, but you know that he wants to do better. That's the key. The parents always will do that and take responsibility. It seems like you have a lot on you. I want to make sure he's going to get back to court.
Yeah.
You know, he's got to keep up with his attorney. And so I'm going to, I will lower the bond sum. I will make it a $2,500 good bond just based on his history. I'll make that $2,500 good bond with, he needs to stay off of MARTA because MARTA, the officers and the residents have a right to ride to be safe and free. Not for sure why he would be on MARTA with a gun. So he is not to ride MARTA. If he needs to go anywhere, he's just gonna have to get Ubers and other type of transportation. But while he's on bond, you know, if they're gonna put him on an ankle monitor, that'll be fine. But I'll have his curfew from uh 8 p.m. to 7 a.m. will be his curfew. He is to go to school, I guess, when it starts, and maybe he needs to go to summer school. I don't know. So he's to still pursue his education and get his diploma. No drugs, alcohol, weapons, or guns while on bond.
With the
And
on your
that's it. I'm
on
sorry.
on your $2,500 good bond, what does that mean?
Let his attorney explain that to you.
I'll give you a call.
Or would you be able to lower a
Basically,
little
go
more?
through a bonding company. Mr. McLean will explain it to you, but basically go through a bonding company. And to make sure he understands. I mean, he's right at 18. So,
Would
but
you
I will give him the surety bond, okay?
would you be willing to go down on the bond just a little more? Because financially I can't. I'm doing the best I can.
So I know you are, and I believe that you are doing the best you can, but we want to make sure that we don't see your son here anymore. You know?
You won't see him again. I promise you. His probation officer, we talked this morning, and he told me he's not gonna violate him because he's giving him a chance that he's gonna work with him.
Yeah, but he's got to get someone. He's got to understand that he shouldn't get in any more trouble, and he's in quite a bit of trouble. So I hope that he understands now to, you know, turn his life around and get started on it, getting some breaks and chances. But you know, I'll make it a 2,000 good bond. That's it. So 2,000 good bond. Okay. And I wish you all the best.
Thank you.
All right, you're welcome.
Next is position 9, Mr. Tillman.
This is 25 CR 003050C, Terrell Tillman. One count failure to obey stop sign, driving while license suspended or revoked, driving possession of open container, alcohol container, and possession of marijuana less than an ounce. Pre-trial?
It's fourth. 2025 suspended license. 2012 malicious injury to property conviction. He's wanted out of Herring County.
Okay. State?
Yes, Judge, this incident took place May 28th, 2025 at 464 Windsor Street Southwest in Atlanta. It's the BP gas station there. Law enforcement observed the defendant driving past that location, a gray Nissan Maxima. He ran a stop sign at the intersection of Fulton Street Southwest and Whitehall Terrace Southwest. This was just before midnight. Officer conducted a traffic stop and approached the vehicle. The defendant admitted that his driver's license was suspended. He stated the vehicle was not his, and that whatever was in the vehicle was not his. Officer detected a strong odor of burnt marijuana coming from inside the vehicle. During a search of that vehicle, the officer found roughly 9 grams of marijuana in a small bag on the passenger seat. Also located a 9mm Taurus pistol in the center console with a scratched off serial number, as well as an open container of champagne in the back seat of the vehicle. Records check confirmed the defendant's driver's license was suspended and that he had an outstanding warrant from Henry County for failure to appear. He was placed under arrest at that time. That failure to appear out of Henry County does appear to be the one he's being held on right now. It does appear to be for driving while license suspended or revoked as well from this year. We have requested a felony transfer for this for criminal use of an article with an altered ID mark, given the firearm with the scratched off serial number. State's recommendation for this, given the open case, the failure to appear, and the felony transfer request still pending, is a $2,000 surety on the driving while license suspended or revoked. And for the and $500 sureties for the remaining counts. No drugs, weapons, or alcohol while out on bond, and no driving without the proper licensure.
Kitty McClain.
Your Honor, as I was looking, the 3 cards started off with UJR on the stop sign and possession of open alcoholic beverage container, driver only, and $1,000 surety bond each on the driving on a suspended or revoked license. And I'm sorry, the UJR was on the marijuana. I've got my arrows misaligned here. So instead of a $2,000 surety bond, Your Honor, I was hoping to ask the court to lower that to $1,000 or a signature bond. He will go to the other county hold. He is 34 years old and is local. His family's here. He's employed at Emory Hospital as a supply tech. And his family's here. And I spoke with them. They were in the process. They obviously haven't made the bond yet. They were in the process trying to make the bond, but they had not yet done so. So I figured 2 o'clock would go ahead and happen. And I was hoping that we could get the court to agree to save them some money. They're going to have to take care of the Henry thing anyway, and make that a signature bond total. Thank you.
I will, on the first charge, $500 signature bond. On the second charge, 500. Third charge, 500. Fourth charge, 500. So that'd be a $2,000 signature bond to be released to his hold in Henry County. It's 500 on each. No drugs, alcohol, weapons, or guns while on bond. And to stay away from 464 Windsor Street Southwest at BP station, stay away from there. And no driving unless he has the proper license, credentials, insurance, registration, all of that. And I guess that'll be it. Anything else, counsel? Did I leave out anything?
No, Judge. I think we've covered everything.
All right.
Is that a signature bond to the jail, correct?
Yes, to be released to his hold.
right, thank you. We can go to position 10, Mr. Williams.
Okay. 25 CR 0030688H, Lonnie Williams charged with one count of unlawful practice as a registered professional nurse. Retrial?
31. On probation for aggravated identity fraud, forgery in the first 3 counts. He got a lot of probation violations and fraud convictions in his history. That's what it mostly is. That's all.
Your Honor, this would be my case. Officers responded to this location, and I'm pulling it up. Here it is. Responded to the address of 4060 at Auburn Avenue North, East Atlanta, Georgia, in Fulton County, in reference to a suspicious person. The officer spoke with a person by the name of Chrislan Stoddard, who works in the HR department of the nursing care facility. She indicated that a man was at the location who is a known imposter as a nurse, based upon him being on the Georgia imposter list. Having been shown to have done this more than once. He has used various aliases as well. Law enforcement took him into custody at that time. Based on the history, Your Honor, based upon his likelihood to reoffend, and the danger that he poses to the community of trying to infiltrate the professional ranks of nurses, we would ask that you give him a $5,000 cash bond. We would ask that should he make bond, he'd be required to stay away from 4060 Auburn Avenue, Northeast Atlanta, Georgia. That he be required to stay at no contact with Miss Chrislan Stoddard, and any other conditions that you deem necessary and appropriate, Your Honor, on your bond order.
UB McLean?
Your Honor, Mr. Lonnie Williams is 56 years old, although on the 3 card it says he was born in Chattanooga. He's originally, as a child, from Ringgold, which is right next to Chattanooga and Tunnel Hill. So he's been in Georgia all his life, essentially. I didn't get a chance to just time constraints in getting to my remote location. I had intended to try to get hold of the statute on unlawful practice, because it did say that he had submitted an application, and perhaps the legislature has covered that behavior as unlawful practice. Otherwise, it would be an attempt. We would ask the court to consider that he does have a local address in Stockbridge, Georgia. His spouse is there. I left a message for the spouse, and we would, even aware of the priors, Your Honor, we'd ask the court to consider a much lower bond than $5,000 cash. We would ask the court to consider a 1 or 2 or as much as $2,500 or 3 surety. Thank you.
Well, my concern is that he doesn't go back to another facility and try to commit this act again. It's pretty serious. And I don't know. I usually, when a person has had the same charge before and been put on bond before, they keep violating it. It's usually my practice to do cash bonds, to hopefully finally get them to stop and not come down here again. I'm going to order a $4,000 cash bond. And with that cash bond, he is to stay away from 4060 Auburn Avenue, but he's also to stay away from any and all facilities where nursing care is conducted. Shouldn't be working anywhere. Maybe try Walmart or some other places, but he is to not work anywhere where there are patients or nursing care going on. So to stay away from all of them in Fulton County, whoever, wherever they may be. No further contact with Crystalline Stoddard. No drugs, alcohol, weapons, or guns while on bond. And that's it for the order of the court.
There was something about a person last name Turner, but I don't know if they did make it the calendar or what.
Turner's on the add-on, number 2 on the add-on calendar.
Oh, okay. That'll be a waiver of presence, Your Honor. Mr. Turner simply asked that he be given an appropriate bond. He had a felony situation. It wasn't. This was a shoplifting of, I believe, he believes this is shoplifting. I haven't looked at the calendar, obviously, since I haven't seen the add-on. But
well, hold on a second. Do we have any other persons in the courtroom that we need to see first? Are we done and we can go to the waiver?
Yes, Judge. I did have a question about John's. He was on the pull sheet, but not on the calendar. Last name Johns, first name Moraine. Yeah.
I don't know.
That case was NOD by the
Oh.
state. We realized that case is beyond the statute of limitations.
Okay. All right. Well, we can go to position 4, Mr. Colquitt, and then the waiver case.
Okay. This is 25 CR 0030628, Harold Colquitt, charged with 1 count of criminal trespass and 2 counts of willful obstruction. Retrial.
Third arrest. You got to open PI in state court. 2013 simple battery trespass dismissed. That's it.
Dave?
Thank you, Judge. This incident took place yesterday at the at 10945 State Bridge Road in Johns Creek. It's the Kroger parking lot. Law enforcement was dispatched in reference to a man punching the window of a vehicle. Upon arrival, the officer advised via radio that the individual was fleeing towards one of the gas stations nearby. Officer observed the defendant running westbound from the BP toward northbound lanes of travel on State Bridge Road. Officer initiated emergency equipment, but defendant continued running westbound across the lanes of travel, entering a parking lot. Foot pursuit ensued. Defendant turned again, began running eastbound. The defendant ran across another lane of travel. Another officer arrived to assist, gave verbal commands for the defendant to stop, warning the defendant that they would have to use a taser. Defendant failed to comply. Taser was deployed, and defendant was taken to the ground with that. He was given multiple commands from officers to place his hands behind his back. He eventually complied with those commands. Officers then went back and made contact with witnesses to the original incident. This was they were called to. Those individuals were identified as Kimbler, McConnell, and Kirkland, who all stated they observed the defendant striking the rear driver's side passenger window of a vehicle at the location for roughly 5 to 6 minutes. Officer spoke with the person determined to be the owner of the vehicle. That was Miss Sylvia Tran. She explained that the car belonged to her and that she wanted to press charges. Officer observed several smudge marks on the window consistent with it being struck by hand. Defendant was arrested. State's recommendation for this case is a signature bond through pretrial services, social worker visit for BHET, no further contact with Sylvia Tran, stay away from the Kroger at 10945 State Bridge Road in Johns Creek. and no drugs, weapons, or alcohol while out on bond, we would sound for Miss Tran if she happened to make it on the line. We have not spoken to her, but we will continue those efforts.
Okay, Ms. Tran, Sylvia Tran. All right, go ahead. Is it PD Tucker?
Yes, Your Honor. Um, we have no objection to the state's recommendation for a signature bond, as well as the other conditions of the bond.
All right, and I don't know if we had an amount, 1,000 on the trespass, 1,000 on each of the structures, a total of $3,000 signature bond through pretrial per judge. That'll be what, a
Two.
level 2. All right, level 2. He's to stay away from the Kroger at 10945 State Bridge Road. He's to have no further contact with the victim, Sylvia Tran. And no drugs, alcohol, weapons, or guns while on bond. All right, I think that's it. Now we'll go to the waiver case. 25 CR 003070J, Quentin Turner, charge of 1 count of theft by shoplifting.
$62. He got a lot. He got a lot of probation holds. He went at felony earlier. He got shoplifting convictions from 24, 23, 22, 22 burglary conviction. He's on probation for 1 shoplifting, burglary 2nd degree shoplifting. On probation for another shoplifting. Got an open case for assault with intent to commit a crime, disorderly conduct, giving false name. It's 25 PI 001960. And another open shoplifting, 25 PI 001961. Yeah, that's it.
Okay. Date?
Yes, Your Honor. This case was initiated on 5/10/25 at around 12:40 p.m. Law enforcement, he was captured on surveillance footage in Didi's Discount Store located at 590 Cascade Road, Southwest Atlanta, Georgia, Fulton County. And he was seen taking possession for his own appropriation. Men's clothing, specifically underwear, shirts, socks, shoes, totaling around or about $195.84. He passed all points of sale without attempting to pay for the items. Miss Gossett or Grosset of the store was able to provide his name and date of birth because he had been there before and was able to identify him by his Georgia ID card. Your Honor, it's I believe his history speaks for itself. He has multiple theft by shoplifting offenses. This would make his 7th of such type charge. 6 prior convictions. This would make a 7th arrest on that basis. Your Honor, we would ask for a $5,000 cash bond. Given his history, he is a danger to the community. He is likely to reoffend. He is likely to return to this location, as we've already heard. He's been here before. Nothing further.
McLean? You're on mute.
Your Honor, he did waive his presence. He said he had a felony situation. Just wanted to ask the court to put the appropriate bond on this as you see fit. The lowest possible bond is what we'd ask for. Thank you.
All right, I'm going to order a $3,000 cash bond. Or with that cash bond, to stay away from 590 Cascade Road. The DDs. With that cash bond, no drugs, alcohol, weapons, or guns while on bond. And Are we no further contact with Ms. Gossett or not?
Yes, Your Honor, I apologize. I should have included that.
Okay. All right. No further contact, stay away, 3,000 cash. Is that it? I think. Number 8 bonded out. That's it, Ms. Strong.
Before we start, what was the no further contact, the person's name for Lonnie Williams?
On Lonnie Williams,
Ms. Stoddard.
yes, Prislon Stoddard.
Could you put it in the chat?
Sure.
Position number 1 was a $3,000 good bond. That's on the last charge, the criminal trespass reset for SAP 612. Position number 2 was a $1,500 good bond reset. Position number 3 was a $3,000 good bond reset. Position number 4 is a $3,000 signature bond through pretrial level 2 per judge. Position number 5 is an $8,000 good bond reset. 6 is a $1,500 good bond reset. 7 is a $2,500 good bond reset. Position number 8 is released. Position number 9 was a $2,000 signature bond through the jail, released to this Henry County hold. Position number 10 was a $4,000 cash bond only reset. Position number 1 on the add-on calendar was an amended bond, but altogether a $6,000 split bond. The initial bond was a $4,000 signature bond through pretrial with a parental cosigner. And the last charge today is a $2,000 good bond. It's reset for 6/12 as well. Position number 2 on the add-on is a $3,000 cash bond only reset for SAP.
Okay. That sounds like it. All right, everybody. Have a good weekend.
Thank you, Judge. You
All right.
too.
Bye-bye.
Bye-bye.